Okay, so as I was mentioning, I'm going to ask you to use the chat function and type in questions as you think of them. And what I'll do is at the end of the program, if we haven't already addressed the question through the remainder of the presentation, I'll answer those questions as they were entered into the chat function. Some people sent me questions in advance, and I'll either try to incorporate addressing those questions into the presentation, or again, I'll also just do it at the end of the Q&A. So I'm going to turn off my camera and pull up the PowerPoint, and we're going to cross our fingers that that works well. If you are not, if within the next 30 seconds you are not seeing my PowerPoint, give me a little bit of a heads up. I think it should be working. Just want to turn off my camera so that it's not sort of a distraction. Okay, sorry for the little technical delays. I just want to make sure that it's working properly. Someone had asked already in the Q&A or in the chat function, I noticed whether the slides would be available after the fact. And actually, I tried to do that in advance this time so that if people didn't have to ask for it. The slides should have been attached to the meeting notice. I did include it in the WebEx program, but what I can also do is I think hopefully I have the ability to send a group email to everybody who registered, and I can send a copy of the slides. Also, a recording of the program will be posted on the Committee on Open Government's website after the completion. Hopefully I should be able to have it up by tomorrow or next Tuesday at the latest. What I do is I download the recording, get it to the IT staff, so it just sometimes takes a little while for us to get it up. But if you go to the Committee on Open Government's homepage, there is a section, there's a menu drop-down box called I Would Like To. Under the I Would Like To drop-down box, you're going to see a choice for View Training Recordings. There's a copy of the Freedom of Information Law training program that I did last month already posted, and then I will post this one it'll get up within the next few days. And I'm going to continue doing these programs. I'm going to alternate every month between the Freedom of Information Law and the Open Meetings Law, so I'll do one every other month. And so if you've already taken the program, it's probably not going to be anything new and exciting. No need for you necessarily to take it every other month, but if you want to share that information with other people that you think it might be helpful for. So I'm doing Open Meetings Law today. Next month I will do another program on the Freedom of Information Law. And I don't have that date yet, but just keep an eye on our website. It'll get posted under our news section. And I will have the pre-registration. I think it's going to work better. Last time, many people told me they had a hard time logging on. I think hopefully with the pre-registration requirement, we'll avoid those problems. Okay, so we'll get started. For those of you that don't know, my name is Kristen O'Neill. I'm the Assistant Director of the New York State Committee on Open Government. I've been with the committee for over 5 years now, started in November of 2015. And prior to that, I was in counsel's office with the New York State Office of Mental Health, and part of my responsibility was to serve as the records access officer. So I had a decent understanding of the Freedom of Information Law when I came to the Committee on Open Government, but knew fairly little about the Open Meetings Law, so that was something new for me to learn. Up on your screen, you'll see my contact information. That's my email address, that's our office telephone number, and of course our website. If you can't remember our website, Google Coog. It's usually one of the first results that pops up on the Google or search engine results. The Open Meetings Law is codified in New York State Public Officers Law, Article 7. A copy of both of the Open Meetings Law as well as the Freedom of Information Law is available on our website. And you can just, if you go to the Committee on Open Government website, there's a drop-down box for FOIL, a drop-down box for Open Meetings Law, and from our website you can find copies of the law, you can find copies of the FOIL regulations, advisory opinions, and case law. There's also a publication called Your Right to Know and some sample templates for different types of either FOIL requests or responses. So there's a lot of good, hopefully practical information available right on our website. It is in the process of getting updated, the website, but all the helpful information will remain. The Open Meetings Law, the intent of the Open Meetings Law is to allow the public to attend and listen to deliberations and decisions that go into making a public policy. The intent was to allow the public to be aware of how public officials come to their decisions and to make sure that they can be aware of what decisions public officials are making. There's an obligation on the part of public bodies to make all reasonable efforts to ensure that meetings are held in an appropriate facility which can adequately accommodate members of the public who wish to attend those meetings. That means under normal circumstances, and I apologize, I meant to preface this right in the beginning, most of my presentation is going to focus under the Open Meetings Law under normal circumstances. However, I will spend some time as we go along pointing out distinctions between the Open Meetings Law under normal circumstances and the Open Meetings Law right now under COVID. So here's one example. Under normal circumstances, public meetings you're required to hold them in a physical facility that can adequately accommodate members of the public who wish to attend those meetings. Of course, right now, given the governor's executive order that came out in March and has been extended monthly since March, the public bodies have the ability to prohibit in-person attendance at their meetings as long as they make the meetings available to the public through some other mechanism, through some remote mechanism, whether that's broadcasting their meetings, webcasting them, whether it's making them available through teleconference or web conference. There must be some type of simultaneous remote access to the meeting while it's going on if a public body wants to sort of shut down in-person access. You can also currently have hybrid policies relating to in-person attendance. So for example, if you have members of the public and board members that don't feel comfortable being in public settings right now, which is not uncommon at all, we sort of felt like we were going in the right direction towards the summer, and then fall and winter hit, and we seem to be going back into not such a great situation. So it's not unusual at all for board members and members of the public to not feel comfortable attending meetings in a public setting. But if you want to have a hybrid situation where you do have public meetings that are open to the public with a physical location, you're also welcome to have that hybrid situation where you offer it through some other remote mechanism as well. Up on the screen right now, we have the definition of public bodies. The likelihood is if you're on this program and you're a government employee or official, you know that your board is likely a public body. The definition is any entity for which a quorum is required in order to conduct public business and which consists of 2 or more members performing a governmental function for the state or for an agency or department thereof, or a committee or subcommittee or other similar body of such public body. And I'm going to talk about committees and subcommittees in a little bit more detail a little bit later on. But these are sort of the bullet points. Are there 2 or more people? Is there a quorum required, is necessary to conduct public business? Is this a body that has the authority to act collectively? And then again, we're going to talk a little bit more about committees. First question is, are you having a meeting? Are you having a meeting that is subject to the open meetings law? First question you ask yourself is there a quorum present? If you have, for example, a 5-member board, examples of boards being town boards, village boards, city council, county legislators, or boards of supervisors, fire districts, board of fire commissioners. There's so many different types of public bodies across the state of New York. There are thousands of units of local government across the state of New York, so for every unit of local government, there's often a corresponding public body that governs that agency, that government unit of local government. So if you have, for example, a 5-member town board and you have a quorum present, a quorum meaning a majority of total membership, if there are no, even if there are no absences, excuse me, let me back up a little bit. It's a majority of the total membership, even if there are no absences or vacancies. Regardless of absences or vacancies, it's a majority of the total membership. So if you're supposed to have a 5-member board, a quorum is always going to be 3. No matter how many people show up to the meeting, no matter how many absences or vacancies you have, a quorum is always going to be 3 for a 5-member board. For a 9-member board, a quorum is always going to be 5. So just think about it that way. Quorum does not change depending on the number of people that show up to a meeting. It does not change depending on the number of vacancies you have on your board. The second question is, are you there to discuss public business? If the answer to those 2 questions are yes, the likelihood is, yep, you're having a meeting subject to the open meetings law, regardless of the intent or lack thereof to take action or how you characterize that meeting. There's no legal distinction between workshops or work sessions or agenda sessions. Sometimes public bodies or agencies like to use those terms, and there have been situations where public bodies have thought, well, it's not a meeting, it's just a workshop, therefore it's not subject to the open meetings law. That's not accurate. If you have a quorum of your board there to discuss public business, it's a meeting subject to the open meetings law. Special meetings, meetings called at the last, on short notice to discuss emergency business. All of those things, with the exception of there is a special reference in certain statutes, such as New York State town law relating to special meetings, but generally there's no legal distinction in any of those terms. We'll talk a little bit more about informal gatherings and pre-board meetings, but generally, if you're there, if you have a quorum for the purpose of discussing public business, it's a meeting subject to the open meetings law. In advance of the program, a couple of people actually emailed me this interesting question about administrative tasks. And I think it's a really good question. Part of it has to do with sharing information and documents with other board members, and part of it has to do with very simple, for example, scheduling. Do we have to have a meeting in order to approve another meeting? And my answer to that is no, I don't think so. If, for example, if you have a board secretary or one board member who's sort of been tasked with the administrative functions of your public body, and you're trying to query the other board members to determine their availability for a special meeting, for example, in my opinion, that's something that certainly can be done via email or by telephone. There doesn't need to be any formal approval. It's just you're querying them for their availability. I think that's perfectly fine to do that via email or even by group text or whatever is the easiest thing to do. Those types of administrative tasks in order, like, for example, I mean, I think that's a common example is we need to schedule a special meeting and I want to see when everyone's available. So I'm going to send out an email and say, okay, here's the dates and times that I think would work as a group for the next week. Can you all let me know if there are times that you're not available? If you want to do that by email, please feel free and go ahead and do that by email. It's not a problem. There's not, in my opinion, no court would determine that type of discussion about a purely administrative task such as that as a violation of the open meetings law. It's just an administrative task to make sure that everybody is available for a meeting. Another question had to do with sharing records. We can talk about that a little bit more because there is a specific provision of the open meetings law. But if you want to have, for example, an application, or like, for example, with New York State, we have SharePoint that's part of our Microsoft program. And within our committee, our staff of our committee, which granted is very small, we have documents that we put up on that SharePoint, and it's a great way of letting each other look at the documents that we think are of interest to each other. Or you can email documents to each other. Okay, this is an article that I found that was interesting. I just wanted to share it with the rest of your board members. This is some data that I found that supports or doesn't support a particular proposal that we're considering voting on next week. I just want to share it with you all to review before the next meeting. Types of those communications, in my opinion, do not constitute a meeting subject to the open meetings law. There's other types of gatherings that people have asked about, that asking me whether does this constitute a meeting subject to the open meetings law. One example is site visits. For example, you have perhaps a school board or a town board, whatever it may be, and they're thinking about purchasing property. And they want to go visit the property, perhaps with the head of their facilities department or some position of that nature, and the head of the facilities department sort of wants to present the pros and cons of a particular property to the board members as they consider whether they want to purchase that property. And in my opinion, that site visit, as long as the board can refrain from engaging in deliberation, if they're just there for the sole purpose of gathering information and listening, for example, listening to the presentation and listening to the facilities manager describe the pros and cons of the property and viewing the property and gathering information for themselves, they just need to avoid engaging in deliberation. But so if they can do that, if they go on this site visit and gather information and avoid engaging in deliberations, in our opinion, that is not a meeting subject to the open meetings law. It's not something that would need to be noticed to the public to allow every member of the public also show up for this site visit. It's not really practical, first of all. I mean, if you're purchasing property from a private entity, for example, you can't necessarily allow the entire public to show up for those meetings. Retreats and educational seminars are another question that come up frequently. When I hear the word retreat, I always want to push back a little bit, because sometimes the word retreat is actually meant to discuss a meeting intended for the members of the public body to discuss long-term goals of the organization, of the government entity. And that's a meeting subject to the open meetings law. If, in fact, they're going on a retreat for team building, it's sort of a get to know you, and here's lessons on how to function well as a public body generically, okay, that's fine, because you're not there to discuss public business. If you go to an educational seminar under pre-COVID circumstances, many organizations, many membership organizations all throughout the year would host educational programs for their members. You had New York State School Board Association, the Association of Towns, NYCOM, Association of Counties, all those different membership organizations would have educational seminars for their members to provide learning opportunities and training opportunities. And they're wonderful programs that we always, the Committee on Open Government, always appreciated being invited to. So there would be many times when I would be present in a room where you might have a quorum of a board also present, multiple quorums of multiple boards present in that room for the purpose of training. But again, as long as they can avoid going off in the corner after the program and discussing business related to their own municipality or school or whatever it may be, it's fine for them to all be in the same room. It's even fine for them to all be in the same room because they are members of the school board, as long as they avoid discussing board business. If they're there for the purpose of gathering information, receiving training, perfectly fine. With committees, if you have a town board, let's even maybe use something a little bit larger. Let's say you have a 9-member city council, and within that city council, you've designated several 3-member committees. And that committee those committees are made up entirely of members of the larger city council. So you have maybe a finance committee, and you have a human resources committee, and you have a parks and recreation committee, whatever it may be. If you have, for example, 3 members designated to serve on each of those committees, meetings of those committees are subject to the open meetings law. Even though it's a less than a quorum of the full public body, which is the 9-member city council, when you break it down to a committee that is made up entirely of members of the larger committee, public body, that smaller committee then becomes its own public body that is subject to the open meetings law. So you have now a 3-member committee that is a 3-member public body. And that committee's meetings must be made open to the public pursuant to the open meetings law. So I'm going to focus on that. However, that does not mean, for example, so you're going to open that committee, you're going to have a finance committee meeting. You have those 3 city council members sitting up on the dais discussing finance committee business. It's open to the public because it's a meeting subject to the open meetings law. 2 other members of the city council want to attend that meeting as members of the public. They are free to do so because it's open to the public. They are allowed to sit in the audience and listen and attend and listen to the discussions and deliberations that finance committee members are having, as long as they refrain from engaging in the deliberations themselves. They cannot make it appear as if, because, if, for example, if you've got 2 city council members that show up to a 3-person committee meeting, you then have 5 members of the city council there. You have a quorum. So you want to make sure that those 2 members that are attending purely as members of the public are sitting in the audience and keeping their mouths closed, because you do not want it to appear as if all of a sudden it has become a meeting of the City Council. Finally, social gatherings around holiday times. Pre-COVID, people would often have, there'd be, for example, a municipality-wide holiday party where everyone was invited to get together for drinks and hors d'oeuvres, whatever the case may be. Sometimes you'd have a quorum of a public body present at one of those social gatherings. Again, the whole point is they just need to refrain from engaging in discussions relating to public business, but they are allowed to attend those social gatherings. This is a question we get quite frequently about telephone calls and emails. A meeting requires, again, under normal circumstances, preface, I feel like I have to say that so many times right now, under normal circumstances, a meeting requires physical presence or presence via video conferencing. Right now, with COVID, the governor's executive order allows members of a public body to also participate via teleconference. So normally, normal circumstances, teleconferencing is not permitted where it's just voice. You would have to have video conferencing. You would have to have both visual, audio and visual. COVID right now, you can have just audio. So a meeting requires physical presence or video conferencing. You cannot conduct a meeting via teleconference or by email under non-COVID circumstances. Even under COVID circumstances, you cannot conduct a meeting by email. If the only thing additional is that you're allowed to have teleconferences right now, whereas you wouldn't under pre-COVID circumstances, and when we get there, post-COVID circumstances. And again, as I mentioned earlier, this does not mean that members of the public cannot share information via email or through some type of share drive. It's perfectly acceptable to do that. You just want to make sure that the first thing I think you should do is avoid engaging in substantial deliberations about the information that's being shared. If you do inadvertently, perchance, engage in those deliberations about the information that's being shared via email, if a public body does engage in any type of deliberations via email, those deliberations really should be repeated in the context of an open meeting. They should be repeated when the public can hear them and can access them, because nothing annoys the public more than showing up to a meeting and having a public body vote on an important topic without any discussion. If the public shows up and hears a public body just vote on something without having ever discussed it, oh, that gets very frustrating to the members of the public, because they do feel like there had to have been some sort of secret deliberations that they were not aware of. And it doesn't reflect well on your public body. So you want to make sure that if you do engage in deliberations via email, please repeat those discussions, express your opinions in a public setting. Notice of a public meeting. The notice of the meeting must include the date, time, and place of the meeting. It should be prior to every meeting, although you are allowed to have, for example, if your agency that hosts the public body would like to put out a single notice to the media at the beginning of the year, you're free to do that. For example, sometimes the town clerk might send out at the beginning of January a schedule for the entire year, and maybe they'll post that schedule for the entire year on their website and on their bulletin board. That's fine, as long as if there are any changes or additions, you need to follow the notice requirements. Date, time, and place prior to every meeting. Notice must go to the media on a designated physical location and on the agency's website. Notice must be provided at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. The law states that for meetings on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. You'll note the actual language of the open meetings law doesn't talk about need to have meetings on short notice. It doesn't talk about emergency meetings. It just says that if you're going to have a meeting on short notice, you have to give, notice must be given to the extent practicable at a reasonable time prior to the meeting, which is sort of fuzzy and gray. The language of the statute of the open meetings law does not state that you have to have a reason for having a meeting on short notice, but I want to point out and make it very clear that the courts have weighed in on this issue. So while the statute is silent, the courts have made it very clear that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice must be dependent on the actual need to do so. You should only be having meetings on short notice, for example, if some type of harm would be caused by delay. That's the type of thing that you should be keeping in mind if you're considering having a meeting on short notice. Minutes. Minutes of every meeting of a public body must include a record or summary of all motions, proposals, resolutions, and matters formally voted upon. Executive session. You're only required to take minutes of executive session if action is taken during executive session. So if a public body enters into executive session and simply deliberates and then comes back into open session to take its vote, no separate minutes of that executive session need to be created. So you'll notice that the actual requirements for what must be included in minutes is fairly narrow. It's pretty simple. That doesn't mean that you can't include more. For example, if you're the town clerk and you'd like to include a little bit more detail in your meeting minutes, you're free to do so. You just want to be consistent. You want to make sure you're doing the same thing each time. You want to make sure, for example, if you're taking notes about public comment or public participation, that you're being consistent about how you treat members of the public. For example, taking detailed minutes and reflecting detailed descriptions of what one person said, but not even acknowledging what somebody else said doesn't reflect well. So you want to make sure you're being consistent, and you have to, at a bare minimum, include what the open meetings law requires. In addition to what the open meetings law requires, there's actually a provision in the Freedom of Information law that requires every agency that contains a public body must maintain a record of how each member votes. So while the open meetings law just says you have to have a record or summary of all motions, proposals, resolutions, or any matters voted upon, and the results of that vote, it just says you have to basically include the results of the vote. The Freedom of Information law requires that you include a record or maintain a record of how each individual member voted. If it's unanimous, it's fine. The minutes can just say it was unanimous. Clearly, you're going to know how everybody voted. But if there's any sort of split, the minutes need to reflect how each member voted. Again, executive session, no minutes necessary if actions are not taken. If you're having a workshop or an agenda session or something of that nature where there's really no intent to take action, and in fact, no actions are actually taken, my recommendation is just to have a brief record that reflects that. For example, maybe the work session has something really simple like a vote to adjourn. Well, include that in the minutes. Just have a very brief record of who is present at the meeting, and the minutes can just reflect no action taken during this work session. From a very technical perspective, at a meeting where no actions are taken, no minutes would be required. My only concern with not having any minutes whatsoever is that there may be members of the public who feel that maybe you just forgot to take minutes. And so creating that very, very basic document that reflects, yes, we know we're obligated to take minutes of meetings subject to the open meetings law. There was a work session that was subject to the open meetings law. No actions were taken. It's just a good idea. I think it's just a good practical step to take when you have something like a work session or an agenda session or something of that nature. It confirms for the public that you know what your statutory obligation is and that you're complying with it. In terms of time limits for open session of a meeting subject to the open meetings law, minutes must be prepared and made available to the public within 2 weeks of the open session. If action is taken during executive session and minutes are prepared, those minutes must be prepared and be made available to the public within 1 week of the executive session. In terms of contents of minutes of the executive session, you want to make sure you can create the minutes and limit the details so that you're not defeating the purpose of the executive session. The minutes do not need to be so detailed that you're defeating the purpose of the executive session. So if it's a matter of not including the name of a particular employee or the name of applicants for employment, whatever the matter is, if it was, you must create minutes, but the minutes can be created in such a way that you're not defeating the purpose of the executive session. Keep in mind that availability of meeting minutes is not dependent on whether they've been approved or whether they're in draft form. Once they've been prepared, they're available to the public regardless of whether they've been approved or not. You're free to mark them draft, you're free to mark them unapproved, but you still need to make them available upon request to the public. You're also not required, there's nothing in the statute right now, although it's been a frequent legislative proposal to make it a requirement, but currently there's nothing in the open meetings law that requires you to post your minutes online. Again, I think it's a great practice, but ultimately saves time for board clerks, for the support staff that are responsible for responding to FOIL requests. If you get those meeting minutes up on the website, nobody has to ask for them, and it saves time and effort for everybody. I think it's a great practice. It's just not a statutory requirement to post your minutes online. In terms of recording, any meeting of a public body that is open to the public must be open to being photographed, broadcast, webcast, or otherwise recorded and/or transmitted by audio or video means. Any member of the public that shows up is free to take pictures or record either audio or video. They don't need your permission. An agency is not obligated to record its meetings under normal circumstances, keeping in mind that right now that if you are having remote access meetings, there is an obligation to record. There's also an obligation to transcribe, which I'll talk a little bit about later. But under non-COVID circumstances, there's no obligation to record. An agency may establish reasonable rules to limit disruption and interference. We have model rules available on our website if anyone wants to take a look at that. But the intent really is you want to make sure that, for example, if people are bringing equipment in, like not just holding up their iPhone, but if they're bringing equipment in, you want to make sure that they're not blocking people's view, that they're not getting in people's faces, that they're not disrupting the meeting with their process of recording or broadcasting. But otherwise, if the public just wants to, if a member of the public wants to sit in the back of the room with their iPhone and hit record, they're free to do so. You don't have to let them, of course, record the executive session. You're only required to allow them to record the open portions of the meeting. An executive session, a lot of what my job is talking about executive session. We get lots of questions about executive session. Executive sessions are part of an open meeting. They cannot be scheduled prior to your meetings. They cannot be completely separate from your meetings. they must be incorporated into an open meeting. In order to enter into executive session, the public body must make a motion, fairly specific motion, to enter into executive session. You must include enough detail in the motion so that the members of your public body and members of the public know you're going into executive session for a proper purpose. It should be not just, for example, repeating the language of the statute, but again, including as much detail, similar to the minutes. Include enough detail in your motion so that the body and the public know that you're entering into executive session for a proper purpose, but not so much detail that you're defeating the purpose of the executive session. An example may be that I move to enter into executive session to discuss an allegation of misconduct against a town employee. Or I move to enter into executive session to discuss the possible acquisition of a piece of property. There are permissible reasons to enter into executive session where harm would be caused by harm would be caused to someone or to the municipality by disclosing the detailed contents of the conversation. So once you make the motion, there has to be a vote on the motion. For example, the head of the board, the chair or whatever, can't just say, we're entering into executive session to discuss personnel matters, and then everyone just scoots. No, there has to be a motion, and there has to be a vote on the motion. Assuming the vote passes, then you may enter into executive session. Up on the screen are the reasons that you're allowed to enter into executive session. These are contained in section 105 of the Open Meetings Law. If you don't see it here on this list, it means that you cannot go into executive session to discuss the matter. And again, it's about harm, causing harm either to a person or to the municipality or perhaps to a third party or to law enforcement. It's about causing harm. Common examples, common situations that come up are discussing proposed pending or current litigation. The motion to enter into executive session, you should be able to identify the litigation because litigations are public records. So when files litigation against a municipality, that's going to be a public record. So there's no really reason not to identify the particular litigation you're discussing. But maybe you want to go into executive session to discuss litigation strategy. Do we want to settle? How much do we want to settle for? How much are we willing to offer? Those are the types of things that might be discussed in executive session that you certainly don't want the other side of your opposing parties to hear about. So the purpose of that would be the purpose of that executive session. Please keep in mind that matters that may possibly lead to litigation, that's not enough, because quite frankly, any decision made by a public body could possibly lead to litigation. There has to actually be proposed pending or current litigation. And the way I look at it is, has someone filed a notice of claim? That's proposed litigation. Has someone actually filed a summons and complaint with the court? That's pending or current litigation. Those are the situations where you can go into executive session to discuss that litigation. Another very frequent reason for entering into executive session is to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So many times I see complaints from the public because the public body's minutes, the motion, and the corresponding minutes simply state that they're going into executive session for personnel matters. It's not enough. It's not enough information to reflect that the public body knows when and when not they're allowed to enter into executive session. It's not enough information for the public to know that the public body is entering into executive session for a proper purpose. I know I've said this a million times already, but I'm going to say it again. Include as much detail as you can to reflect that to the public and to the body that you know you're entering into executive session for a proper purpose without defeating the purpose of the executive session. Again, there's many more reasons for entering into executive session. Here's my slide in big, bold words. Don't use the word personnel in your motion. The word personnel does not appear in the open meetings law. It has to be more specific than that. So you want to be as specific as possible. A lot of questions I get about from the public is about public participation. I have to, unfortunately, let many people know that they're under the open meetings law. There's no statutory requirement that a public body allow for public participation at a meeting of a public body. Again, I'm not talking about hearings. There are numerous other statutes that govern public hearings, and those other statutes contain public comment, public participation obligations. I'm simply talking here about the open meetings law, which encompasses hearings, but goes beyond hearings. There are many, many meetings subject to the open meetings law that are not hearings, and that's what I'm talking about here. At a normal monthly or bi-monthly meeting of a town board, there is no obligation for that board to provide for public participation. If a public body is going to allow for public comment or public participation, which many, many, many boards do, they're allowed to establish reasonable rules governing that public participation. Reasonable rules include time limits, for example. Sometimes the rules have to do with content of what can be discussed at a public meeting. For example, you may have a rule that people can only speak for 3 minutes. You may have a rule that, for example, I know a lot of school districts have rules that say we do not accept public comment where members of the public are discussing specific employees. And as long as you are implementing that rule fairly and consistently, in our view, it would be permissible. But on the other hand, if you're going to allow, if I show up at a meeting of my school board and want to stand up and talk about what a wonderful, wonderful teacher my daughter's AP American History teacher is and how I think she deserves every award in the book, if they're going to let me stand up and talk like that about one teacher, they need to also, the board would also need to let the next parent stand up and talk about what a terrible, terrible teacher they think their child's biology teacher is. So many boards just say no public comments about our teachers, about our employees. And as long as you implement that fairly and consistently across the board, I think that would be permissible. Records scheduled to be discussed. Okay. No, many times we get questions about agendas. The open meetings law is silent with regard to agendas. There's nothing under the open meetings law that requires a public body to prepare an agenda, or even if they do prepare an agenda, there's nothing that requires that they stick to it or that they follow the agenda. They can add to it, they can delete from it. The open meetings law is just silent on agendas. But what the open meetings law does require is that any proposed resolutions, laws, rules, regulations, policies, or any amendments thereto, or any records or portions thereof that are public under the Freedom of Information Law shall be made available upon request prior to or at the meeting. In addition, those shall be made available online prior to the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. So if you have, for example, proposed resolutions that your public body is going to vote on. Those resolutions should be made available to the public prior to or at the meeting. They should be posted online for the public to view prior to the meeting, if you have the ability to do so. Same is true, laws, rules, regulations, policies. If a board is reviewing a particular document, assuming that the document would be available to the public under the Freedom of Information Law, if the board is going to be discussing the details of that document in an open setting, there's really no reason not to allow the public to also be able to see that document and follow along with the board's discussions. So that's an obligation under Section 103 of the Open Meetings Law. These records are required to be made available to the public prior to or at the meeting, and if possible, they should be made available online. So while there's no obligation to have an agenda, there is sort of, I know many public bodies refer to them as agenda packets. These are the documents that we plan to discuss at the next meeting. Those are the types of records that are supposed to be made available to the public so that they can follow along. Exemptions. So there are two mechanisms that allow a public body to meet behind closed doors. The first is executive session that we've already talked about, and the second are exemptions. If an exemption applies, the Open Meetings Law does not apply, as if the Open Meetings Law does not exist. In Section 108 of the Open Meetings Law, there are three exemptions from the Open Meetings Law. First is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and the Zoning Boards of Appeals. So a judicial or quasi-judicial proceeding, for example, it could be a board of ethics. If you have a board of ethics that conducts quasi-judicial proceedings as a board, and then that quasi-judicial proceeding would be exempt from the requirements of the Open Meetings Law. The second type of discussion that is exempt from the Open Meetings Law are deliberations of political committees, conferences, and caucuses. An interesting aspect of this exemption is that if you have a board, if you have a public body that is made up, for example, of 3 Republicans and 2 Democrats, and those 3 Republicans, they can meet anytime they want and discuss anything they want. They are not limited to political discussions. They can discuss anything they want, including town board business. The law is clear that even if you're constitute, for example, a 3 Republicans on a 5-member town board, those 3 Republicans are going to constitute a quorum of the town board. But still, under Section 108 of the Open Meetings Law, they can meet whenever they want, wherever they want, without any notice to the public and discuss whatever they want. They can't vote, but they can discuss whatever they want. An exception that has been established in case law, not by the Open Meetings Law, this is by an exception that's been established by the courts. There was a situation where there was a particular public body that was made up entirely of a single political party. You had for example, you had a 5-member town board, and all 5 of them are Democrats. Then that town board can still have a political caucus, could still have a political committee meeting where all 5 of them attend. However, the courts have held under that very specific situation where all members of the body are made up of the same political party, under that very specific situation, they have to limit their discussions to political business. Anything other than political business, any town business needs to be discussed in the context of an open meeting. That's established by case law. The third exemption is discussions relating to any matter made confidential by federal or state law. Examples of this are if you're a school board and you are having conversations relating to students, Those conversations relating to a student and the student's educational record is confidential pursuant to federal statute. A very, very common example of this exemption is a meeting with a public body, between a public body and their represented council. So you have a town board or a school board, and they meet with their school district attorney or their town attorney to have a conversation that is covered by the attorney-client privilege. That discussion is confidential pursuant to New York state law. There's provisions of the civil practice law and rules that encapsulates the attorney-client privilege, that conversation. So where this gets confusing is sometimes public bodies state they're going into executive session to have a conversation with their attorneys. Public bodies want to make sure that they're clear about why they're meeting behind closed doors and under what section of the law they're doing it. If you are going into executive session to discuss litigation strategy pursuant to relating to a particular litigation, you can enter into executive session to have that conversation. However, if you want to meet with your attorney for the sole purpose of requesting and receiving legal advice on a particular issue, does not just have to be litigation, could be contract negotiations, could be anything that involves receiving the expert advice of your legal counsel. If that conversation is covered by the attorney-client privilege, it can be exempt from the open meetings law entirely. But you want to make sure you're being clear about that. If during the context of an open meeting, you want to meet behind closed doors to have a conversation that's covered by the attorney-client privilege, please, please, please do not say you're going into executive session. Because the next day, I'm going to get about a half dozen phone calls complaining about you, saying, they said they were going into executive session, but there's no executive session that allows them to go in for that reason, and I have to go through this conversation with about a half dozen people. Make it clear that you are having a conversation that is exempt from the open meetings law pursuant to Section 108. Noncompliance and enforcement. Enforcement, the Committee on Open Government does not have enforcement authority. People sometimes call us and say, I want to file a complaint. Then I'm happy to listen to your complaint, but I do not have enforcement authority. I don't have investigative authority. We provide advice regarding the Freedom of Information Law and the Open Meetings Law. We do not have enforcement authority. Enforcement is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. So for example, if a public body, if a member of the public believes that a public body took action at a meeting that was held in violation of the open meetings law, or as a result of substantial deliberations that occurred at meetings in violation of the open meetings law, any affected party can bring CPLR Article 78 proceeding in state Supreme Court. If the petitioner wins, if the petitioner prevails, the court has the authority to award a cost and attorney's fees to the petitioner. They could potentially invalidate the action taken depending on how serious the court determines the violation was. So a petitioner prevailing in an Article 78 does not automatically result in an invalidated action. It's going to depend. The judge is going to have discretion there to determine was the violation of law so significant that we believe it should result in an invalidated action. That's at the judge's discretion. The court also in the statute has the ability to require that a public body take training from our office. So you see my beautiful face at some point. Always keep in mind that anyone is welcome to contact our office by phone or by email with questions, and I mean anyone. Government employees, members of the public, media representatives, anyone that has a question about the Freedom of Information Law, the Open Meetings Law, welcome to call our office or to email our office. I gave you my direct email address at the beginning of the presentation. We also have an office address. So for example, if I win the lottery tomorrow and am no longer employed by the Committee on Open Government, there's still a way to get through to somebody at the office. This COOG account is our general office that all employees have access to, so you can always contact us via that as well. So now I'm going to go back to, I want to be able to see, stop sharing, sorry, and, oh, my mouse is being difficult again. Oh, no. Sorry, I just want to go back so you guys can, so I can see you. So see the chat function. Sorry, my mouse is being difficult. I hate when this happens. It won't let me scroll. Let's see if I can do it on my desktop. I want to be able to pull up the chat function, and it's not letting me. Let's see. Oh, this is very frustrating. There we go. All right, first, before I go to the chat function, I just want to take a quick scan through the emails that I received prior to the program starting and see if I can, I had some questions about email, virtual meetings, and shared documents. Someone asked whether they could create a shared Google document repository. I think I talked about that a little bit, and I think that's a great idea. There's nothing wrong with that. There's nothing that prohibits you from sharing documents via email or some sort of Google Docs program, something like that, where you can put it all in a shared location for all your fellow board members to access. I think that's a great idea. In terms of corresponding with your fellow board members via email or text, I addressed this a little bit, but I'm happy to talk about it again, is that I think if you're engaging with them via email or text for purely administrative functions, I have no objection to that whatsoever. Go right ahead. It's just, I would encourage you not to engage in substantial deliberations via email and text. The case law on the subject is a little bit iffy, but it just doesn't reflect well on your public body, and it could potentially expose your public body to legal liability. The best thing to do is if you're engaging in substantial deliberations regarding the pros and cons of a particular issue, is to have those conversations in public. Another person also asked questions about housekeeping tasks. That's the same thing as those administrative functions. I think that's perfectly fine to do that via email, not a problem. Go ahead. In terms of, someone asked about minutes from executive session, I think I talked about that, but again, they're not required unless you vote. If you don't vote on anything in executive session, you don't have to have separate minutes for executive session. If you do vote on an issue in executive session, you can prepare the minutes in such a way where the minutes, disclosure of those minutes would not defeat the purpose. You don't need to identify particular employees. You don't need to, for example, if you voted, you went into executive session to discuss litigation strategy, and you agreed to a cap on what you would be willing to settle for as a board. You don't need to include the cap in the minutes. Just say there was a vote to agree to a cap, something of that nature, or there was a vote. Consult with your attorney about what would and would not cause harm, but just prepare the minutes in a way that does the best you can without defeating the purpose of the executive session. Let's see. If a municipality's common council has rules providing for public participation and/or participation by certain other specifically designated parties, but then participation is eliminated without undertaking a vote, it doesn't really raise questions relating to the open meetings law. But my feeling is if rules are established by consensus of a common council, in order to change those rules, I think you would need to have the consensus of the Common Council. You'd have to have a vote. I understand that particularly early on, in March and April of this year and going forward, a lot of things had to happen quickly. So there may have been changes to the way your public body performed and did its work, and those changes may not have gone through a very formal process of changes to local law or changes to board policy, and that's particularly understandable. But generally, I think changes to your board policies should be done via vote. That's just, you know, a general, but understanding that that may not have happened in during early times in COVID. There's questions about appointments to standing committees, and that's not really governed by the open meetings law. Whether their names would need to be public, yes, because the meetings need to be public. If you have appointees to a standing committee, if we're talking about committees that are made up entirely of the larger public body, then the answer is yes, that needs to be public. And that just reminds me that I want to talk a little bit about advisory committees, and I think that's another question that has come up. So we can talk about that. Let me just skim a little bit here. Someone asked a question about Article 78. I think the frustration with the frustration with the person who posed the question is that it seems, and I hear this complaint from the public quite a bit, is that they feel that public bodies have the ability to do whatever they want, whenever they want, without repercussions, because the only way to get enforcement is for somebody to pay money to an attorney to bring in Article 78, and most people are not willing to do that. And I fully understand that concern. I think a couple of options are available. One is that these, to a large extent, many of these people are elected officials. If you feel they're not doing a good job, that's what elections are for. If you feel they're not acting in a transparent manner, that's what elections are for. Another is take advantage of the press, if you can. The media is doing a wonderful job out helping us. You know, sometimes there's tension between media and government employees, but to some extent, we should be working together to help the public. And if members of the public feel that their public body, their government agency, their municipality is not complying with the open meetings law, maybe you have a reporter that covers local government, and getting them involved in conversations might be helpful. Also reaching out to us. Sometimes the members of the public body just don't realize it's just they've always done something a certain way, don't realize that they're doing it wrong. Reaching out to our office for advice. I don't have enforcement authority. I can't tell them that what they're doing, that they have to change their practices, but sometimes hearing advice from our office can encourage change. I want to talk about advisory bodies and ad hoc committees that are made up, often either they're made up of combinations of members of the public body and members of the public, or else they're entirely members of the public. Generally, my answer is going to be that those advisory committees, those ad hoc committees, are not subject to the open meetings law. And I'm going to tell you, sort of give you some bullet points about what I look to help me decide whether that's the case in a particular situation. So the first thing I'm going to try to find out is this particular committee, advisory body, ad hoc committee, whatever it may be, is it created by New York State statute? I'm not talking about local law. I'm not talking about executive orders. I'm talking about New York State statute. is there a provision of New York State law that requires that this body exists? At the local level, an example of this are comprehensive planning committees. They're purely advisory in nature, but there's a provision of New York State town law that requires that they exist. And it sort of establishes the makeup of those comprehensive planning committees and how they function. So while they are purely advisory in nature, they're created by state statute, they serve a statutory function. That's the first question I look to. Do they serve a New York State statutory function? If the answer is yes, likelihood is that they're subject to the open meetings law. The second question I look to, the second question I ask is, who's on this board? Is it made up entirely or primarily of members of the larger public body? You have a 9-member city council. Well, let's use the example of a school board. If you have a 9-member school board and you establish a 3-person personnel committee, and you also ask for the director of human resources to sit on this committee for the school district, I think the mere addition of the director of human resources is not going to take that committee out of the requirements of the open meetings law. On the other hand, perhaps you have a, I'm trying to think of a good example at any sort of, let's say you have a Parks and Recreation committee at the city council level, and you have 1 or 2 city council members, and in addition to that, you have the director of the city's Parks and Recs department, and you have members of the public, maybe you have students on it, maybe you have business owners on it. You have a combination of all different people that are serving on this committee in addition to government officials and government employees. If that's the case, the likelihood is it's not going to be a public body subject to the open meetings law. And the last thing I'm going to ask is, does this advisory committee, ad hoc committee, whatever it may be, does it have the authority to make final decisions on behalf of the municipality? Does it have the ability to spend money on its own? Does it have the ability to make final decisions, or does it just have the authority to make recommendations to the larger public body? Oftentimes, these advisory committees just have the authority to make recommendations to the larger public body, and then the larger public body is the entity that makes the final decision. So if it does not have the authority to make final decisions, likely not a public body subject to the open meetings law. Another question is, if a municipality's charter requires certain public meetings by the city's common council and the council fails to hold 1 or more of these meetings, does this constitute an OML violation? It's not going to, the open meetings law doesn't dictate what meetings must be held. It just dictates how the meeting must be held once it's established that it's going to be held. If there's a requirement that a specific type of meeting be held, for example, many different like town laws and general municipal law, whatever it may be, there's often a requirement for an annual meeting in January. I forget what it's called. I'm having a senior moment and forgetting what it's called, but I'm sure most of you know what I'm talking about, is that there's a requirement in statute in New York State law that requires that certain types of meetings be held on an annual basis. And so that's not governed by the open meetings law, it's governed by some other statute. Once the meeting is required to be held, then the open meetings law kicks in and tells you how to hold that meeting. Let's see. The meeting's held, but such a short amount of meeting time is allotted as to negate or undermine the meeting requirements. Public participation requirements, I'm not really sure exactly what that means, but as long as they're able to do what they're required to do, as long as the board is getting its work done, it's not a really, I guess the short answer is it's not an open meetings law question. And under the open meetings law, there's no statutory requirement for public participation. I think the rest of the questions that are right in this little section here don't involve the open meetings law, but if the person that submitted them would like to follow up with me, they're welcome to do so. Just want to see if anything, the pre-presentation questions, I think I've addressed those. So now I'm going to start going through chat. First, will slides and Q&A be available after the presentation? The answer is yes. You should be able to get the slides. You should have access to the slides already, but if that's not the case, I think I can send a blast email out afterwards. The recording will be available afterwards. Someone asked if the audio was on. I hope it was. Hope somebody would have told me if it wasn't. How can a remote meeting option be made permanent? That would need to be through legislative changes. You'd have to consult with your New York State legislative representatives because that would require a legislative change. Right now, the only reason you can have remote meetings is through executive order. That's not going to last forever. So any permanent change would need to be made through legislation. The next question has to do with providing recordings and transcripts of virtual meetings. That's an obligation under the governor's executive order. If you are having a virtual meeting, if you are prohibiting in-person attendance or limiting in-person attendance and instead having some sort of contemporaneous remote access, the governor's executive order says that the meeting must be recorded and later transcribed. Follow-up question is, are minutes the same as transcription? And the answer is no. As you know, from our earlier conversation, you'll see that statutory requirements for meeting minutes is very narrow. And you still have that statutory requirement to prepare meeting minutes. That's a separate requirement. The transcription requirement was established by the governor's executive order. And it's all I can say about that is that it's a governor's office executive order requirement. It's not required under the open meetings law. My recommendation is to look into, I'm hoping that most municipalities have not had to engage in any significant costs or time to prepare these transcripts. It's my understanding that programs like Zoom and WebEx have options available. I don't know that they're free options, but there's options available for preparing transcripts. I've done it myself with WebEx, where they've given me the ability to, New York State has given me the ability to have transcripts prepared of my meetings. I think Zoom has that option. There's a program called AI Otter, like the animal, that has fairly low-cost transcription services if you have the recording already, but you need a transcript. But there's no time limit set forth in the statute for having a transcript pre-prepared, so certainly I wouldn't worry about making it your primary responsibility when I know many municipal clerks and support staff have 100 other things to do. Try to find a simple mechanism that will fit your needs. Let's see, what about sharing information such as a follow-up to this WebEx with our board members? Yeah, if you want to share, for example, if someone would like to share a copy of our PowerPoint or something that they learned during this presentation, like, oh, FYI, I just learned that we need to vote on going into executive session, and we haven't been doing that for the past 5 years. Definitely do that by email, not a problem. Question is, we have about quorum. We have a 7-member board with 2 vacancies. We would need 4 members present in order to have a quorum. The answer to that is yes. So if you have a 7-member board with 2 vacancies, a quorum is still 7, or excuse me, a quorum is still 4 because it's based on 7, not on 5. Oh, my stupid mouse. Trying to scan and scroll down. now. Even my mouse pad does not want to work for me, and I'm very, very frustrated. Scroll. Sorry, everybody. See if I just, no, my arrows don't want to work. My mouse is being, there we go. All right. Another question is about I believe the question is about under COVID. Under the COVID rule, can you just have audio and no video? The answer to that is yes. If you want to, for example, provide a call-in, a teleconference call-in number to either other board members or to the public or both, you can do that. You do not need to have video. Another thing I'm going to go back to really quickly, since this idea of audio and video came up. An obligation under normal circumstances under the open meetings law is that if you have any members of your public body participating by video conference, the notice of your meeting is supposed to include that information. Notice of your meetings is supposed to state that we have members participating via video conference from this location. For example, maybe your primary meeting site is in Albany, but you have video conferencing from Buffalo and New York City. That's what we as the Committee on Open Government do. We have essentially Albany, under normal circumstances, Albany is where I work, Albany is where our executive director works, so that's where our primary physical location is, and then we have members of our committee that participate in Buffalo and in New York City. So when we notice meetings of the Committee on Open Government, that notice has to include the physical address for Albany, for Buffalo and New York City, and the notice is supposed to state that the public is welcome to attend from all locations. This is true whether it's a New York State or regional committee like the Committee on Open Government, or whether it's a town board who has a member that wants to participate while one of their members is on vacation in Boca Raton. If under non-COVID normal circumstances, if you have board members that are attending via video conference, the notice must state where they are attending from and that the public is permitted to attend from any location. Under COVID circumstances, if you have members participating either via teleconference, if you have members of your public body that are participating either via teleconference or video conference, you do not need to include their physical location in the meeting notice, and you do not need to allow the public to attend from where your board members are attending from. If someone is quarantining at home, clearly they are not required to open their doors to the public. So you have the non-COVID rule and you have the COVID rule. Someone made a comment that says the city requires we post our minutes online. That's great, do it then. It's not an open meetings law requirement, it's a city rule. Whatever the city requires, do it. Someone said that someone wanted an overview of the slides before closing. I'm not going to do that, but the slides will be available and the recording of the meeting will be available after the meeting, so you can always go back. Question, is it allowable to schedule and notice an executive session to begin prior to the normal meeting time? No, 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 no. You cannot. Executive session must be part of an open meeting. If you tell the public that your meeting is starting at 7 and the public is not allowed access to the meeting until 7 o'clock, you cannot have an executive session that starts at 6:30. You can only enter into executive session after a proper motion and vote during an open session. Then you can enter into executive session. Let's see. Someone said they have a question, quorum requirements, but I don't see the question. Can you clarify that if a planning board wishes to get advice subject to attorney-client privilege, it is under Section 108 and not executive session? That is correct. Any conversation that's covered by the attorney-client privilege is an exemption, not likely not an executive session. Does 72 hours meeting notice include weekends? Yes. If something was not intended to include weekends, it would be counted in business days. When you see something counted in hours, that's going to include everything, including holidays and weekends. Someone asked about phone or email chains where a quorum is ultimately engaged. I think we talked about that to a large extent already. Open meetings law in relation to meetings where government officials have selected and or appointed the membership of a committee or board, which is not. All right, so this question actually ultimately has to do with these police policy reform committees that were established under the governor's executive order 203. And we've received quite a few questions, and my executive director and I looked into it. And based on the makeup of these committees and how and why they were created, it is our opinion that these particular advisory committees and task force are not public bodies that are subject to the open meetings law. That is not me saying that there are not other obligations for this process to be transparent and open to the public. You need to comply with the governor's executive order and the guidance put out by the governor's office relating to those task force, because there is direction from the governor's office about transparency in this process. It's just that it's our opinion those particular task force or advisory committees or whatever you want to call them are not subject to the open meetings law. They don't meet the requirements for being subject to the open meetings law. Question is, if the agenda of a local body lists an item labeled communication, the content of which communication is not made clear and the communication used as the local body's method to read and lay over for vote at the following public body meeting, are they required to include the text of the communication in the first reading? I'm a little confused. Basically what the open meetings law, excuse me, my nose is running. What the open meetings law says is what's required to be made available is records scheduled to be discussed. So it would depend on, are they planning to discuss the contents of that communication at the meeting? If they plan to discuss the contents of that communication at the meeting, then yes, the answer is yes, it should be made available pursuant to Section 103 of the open meetings law. If not, if they don't plan to discuss the content of the communication, no, I don't think it needs to be made available pursuant to 103. Let's see, only have like one more minute. I just want to see what else. I'm going to skim a little bit. I mean, I don't mind going over a little bit, but I don't want to take up other people's time. Public comments. Yeah, the public comment, the rules relating to public comment is not governed by the open meetings law. Just assuming it's just a meeting. Again, open meetings law is silent with regard to public comment and public participation. If it's a hearing, that's an entirely different ball of wax, but if it's just a meeting of a public body, those rules are generally established by the local municipality. Someone asked whether voting was allowed in executive session. I'm going to have one answer for everybody except for school boards. The answer for everybody except for school boards is yes, you can vote in executive session, but if you vote in executive session, you have to prepare minutes of the executive session. So often public bodies just decide to deliberate in executive session and vote in open session because if you have to prepare minutes of the vote, why do it behind closed doors? But if you feel that it's most appropriate to vote in executive session, yes, you're permitted to do so unless you are voting to appropriate public monies. That's the exception set forth in the statute. You're not allowed to vote to appropriate public money in executive session. School boards have other requirements pursuant to education law. There are very few things, and it has to do with disciplinary proceedings. The only time a school board is allowed to vote in executive session is when it relates to that disciplinary proceeding. But that is a requirement of education law, not of the open meetings law. Question is, does a SUNY campus where I work have open meetings for the public like our city has? It's not the campus. Open meetings law governs public bodies. And for example, if every SUNY, there's the Board of Regents at the very high level, but each individual SUNY campus is going to have a type of governing body, and meetings of those governing bodies are going to be open to the public. At the very high level of the Board of Education, the Board of Regents, there's all sorts of different levels within SUNY, and it's the governing body that is subject to the open meetings law. So that's a late to meeting. I'm going to skip over because it's also addressed, and they can go back and view the recording. Yes, can be posted online. Public bodies required to share recordings of teleconference meetings. Once the meeting has been recorded, it's a record subject to the open meetings law. So yes, it would need to be shared if someone made a request for it. Advisory committee made up of 6 legislators that has no authority to make decisions, only required to make recommendations. Yes, if it is a committee that is made up entirely of members of the larger public body, it is a public body itself subject to the open meetings law. That's clear from the definition of public body in the statute. New York City community boards have memberships of up to 50 members, but if they don't have 50 members, must they still have 26 members present for a quorum of the entire board? Unless there's some other statute that I'm not aware of, the answer is yes. If you have a 50-member board, then 26 members is the quorum. The meeting is streamed live to YouTube and saved for later viewing. Is transcription still required? Under the executive order, the answer is yes. It's not a requirement of the open meetings law. My YouTube meeting video provides a transcript online. Is that sufficient? My answer is wholeheartedly yes. Is it as easy as possible for you? Is it proper for a board chair to host the Zoom as opposed to a staff member? Here's my guide on this. It's not addressed by the open meetings law. It's a practical question. My recommendation is to have a non-board member host and have sort of administrative oversight over the meeting, because trying to multitask is difficult. As you can see, this is for me doing, I'm trying to multitask. I was not able to, for example, answer questions in the chat function while I was looking at the PowerPoint. So it's just good to have a staff member that is, for example, solely dedicated to keeping an eye on the remote access program to see if there's anything that needs to be done. I just think that's a good practical suggestion. Transcription is tied to the executive order. It is not tied to the open meetings law. Meeting would be open to the public at earlier time. In terms of going back, I think, to an earlier question about executive sessions held prior to the start of the regular meeting. They said the meeting would be open to the public at an earlier time, but also notified that the board expects to immediately move to go into executive session. I guess the point being is that the public needs to be aware that they have the right to be present while the motion to enter into executive session is made. If you tell the public that the meeting starts at 7, however, it is our intent to make a motion to enter into executive session for the first half hour of the meeting, and that the open session would then follow starting at 7:30. I think that's permissible. You certainly want to be clear that the public has a right to, right now, whether it's log on or be physically present at the beginning of that meeting. Do I have to show my face if attending meeting via Zoom? Right now, no. Under normal circumstances, yes. Executive session, you can vote during executive session. Do you have to motion to go out of executive session? No. I don't know what that question means, sorry. Does the 50-person cap on meetings include board members? I don't know if you're talking about like the governor's executive orders. I can't really weigh in on that. It's an it's a size restriction, so I don't think it really matters. It's not really my area of expertise, but I don't really think it matters who the person is. It's a size limitation. When a public body meets but not for public business, does this meeting need to be held publicly anyway? I'm not really sure what that means. Why else would they be meeting? Must an anticipated executive session be listed on the agenda? Earlier I mentioned that there is no, open meetings law is silent with regard to agendas. There's nothing in the open meetings law that requires a public body to prepare an agenda or to follow one if it was followed. And it looks like that's it, because I've gone overboard and probably everybody needs to go back to work. But I really appreciate everybody logging on today. Next month I'll get a program on FOIL scheduled within the next week or so, and then again in 2 months' time I'll have another one on the open meetings law if you want to let friends and colleagues know that these programs will be ongoing. Hope you're all doing well. Stay healthy. Have a great day.